supplementary cause list, item number 1 for pronouncement of judgment.
Who's for the other side?
Mr. Devnath, Your Lordship.
I'll read only the operative portion. In the light of the above observation, this court is convinced that the petitioner, delinquent, has not been furnished with a copy of the said inquiry report and therefore was prevented from filing a response to the same. Violation of natural justice has occurred. The subsequent action taken by the concerned authority, including imposition of the penalty of compulsory retirement from service, as is found in the impugn order dated so and so, cannot stand the test of judicial scrutiny. The same is accordingly hereby set aside and quashed. Consequently, the authority concerned is hereby directed to reinstate the petitioner in service with all due benefits, including back wages to which she is entitled to in accordance with law, had she not been issued with the said impugn order for which she was compulsorily retired from service.
Oblige, Your Lordship.
Oh, Mr. Devnath, you came a bit too late.
Sorry.
Sorry, the procedure was not followed. Your inquiry report was not supplied to the petitioner. So you take back the, how is the record to be sent back to you? You take it back or?
I'll take back.
You take it back. So registry will do the needful. Thank you.
May I please, Your Lordship? I beg to mention matter number 3, Your Lordship. I pray for 3 weeks' time, Your Lordship.
Item 3. Hello?
3 weeks, Your Lordship.
On prayer made by the petitioner. This is matter.
May I please, Your Lordship?
Yes. Tell me. Are you in this case?
May I please, Your Lordship? I'm appearing. Item number 3, Your Lordship.
Yes, yes.
Supplementary list.
Not supplementary. Not supplementary.
Lordship, I'm being described by Senior Mr. A.
Supplementary list.
It's a main list, Your Lordship.
In the main list.
I'm sorry, Your Lordship. I'm appearing in supplementary list. Item number 3, Your Lordship.
Supplementary?
There's no.
Item number 3 is not there in the supplementary.
Are you sure you're in the right court? Just check.
Lordship, I'll just check out. Lordship.
You're
I'm
right,
sorry, Your Lordship.
You're right or wrong?
No, I'm in the wrong court, Your Lordship.
Fine. So on prayer made by the petitioner, this is matter of the 3 weeks.
Highly acknowledge, Your Majesty.
May I please, Your Lordship, I beg to mention item number 2 from the main list.
Why 2?
Your Lordship, this matter is being taken up by DV, which will be coming up on the month of November, Your Lordship.
On prayer made by the petitioner, seeking accommodation on the ground that the subject matter in this petition is also the same subject matter taken up by a division bench of this court in similarly situated cases. Therefore, matter can be therefore it is prayed that this matter may be put on hold for the time being. As prayed for, this is matter after 4 weeks.
Oblige, Your Lordship.
May it please, Your Lordship. Lordship, I beg to mention item number 8 and 9, Lordship. The arguing counsel, my lord, he is down with the flu. He is not in a position to, my lord, appear with this honorable court today, my lord. 8 and 9, Lordship. I have taken the counsel from the other side, Lordship.
Yes, you have to argue this matter.
Yes, Lordship.
But you're also there in 6 and 7.
Yes, Lordship. I think she's appearing, my lord. She's connected.
8 and 9 on pre-made by the petitioner. Let's just matter up to 2 weeks.
After vacation, after puja vacation, my lord.
3 weeks.
Deeply Lordship.
In that case, Your Lordship, I'm back to mention item number 6 and 7 as well, Your Lordship.
Why?
Your Lordship,
You have to reply.
as Your Lordship, on the last occasion, it was being said that the Sir Christoph Paul is going to argue from his part, so we were.
Oh. But you see, as far as this 6 and 7 is concerned, the petitioner has given their reply. Well, Mr. Sawa, you are there in this, in all 4 cases? No, only 2 matters. Only in 2. So 8 and 6 and 7. So as far as the respondent, your respondent won, Miss?
Yes, Your Lordship.
Yes, you should be.
Yes, Your Lordship. I'm appearing on behalf of
How many
respondent
respondents are
number
there? 2, 3.
Item number 6, only 1 respondent.
Only 1? You are not there.
In 7, 8, and 10.
Madam, in item number 6, there's only 1 respondent. In item number 7, there are 2 respondents, the CBI as well as the accused A3.
Okay. Okay, A2 is not in.
So far, we have concluded our arguments in item number 6.
Is it 6 and 7 or just 6? Is it in 6 and 7 or just 6?
Only 6.
But so far, we have concluded our arguments only in 6. Only in 6. We haven't touched 7.
Okay. So, 6, there are 2 respondents. Only 1.
One.
So, you are to reply.
Yes, Your Lordship.
6 only 1.
On prayer made by the respondent, having 6 more. Matter is adjourned. Same not be objected to by petitioner. List the same after 3 weeks. 8 and 9 आएगा no? 3 weeks. Excuse me. So in 7 there are
2 respondents.
but this matter has not been taken up. So it will be taken up.
Yes, Your Lordship.
No, madam.
Fine.
Much obliged, Your Lordship.
Obliged.
Daily cost list, item number 1.
May please Lordship. Lordship, in this matter also respondent number 1 to 5, this is council along with the President's AM Lordship. Respondent number 7, they have filed a counter affidavit Lordship. The respondent 6 is yet to file a counter Lordship.
My lord, the affidavit is ready today, my lord. We will be filing in the course of the day. You kindly grant us the day's time, your lordship.
And what about 7?
We have filed, Your Lordship.
You have filed.
1 to 5 is fine.
You have also filed.
Yes, Your Lordship.
Letter counsel for the respondent number 7 has submitted that the counter affidavit on behalf counter affidavit has been filed. Could not be filed. Respondent 6 could not be filed, but will however be filed in course of the day, for which accommodation is sought for. As prayed for, the respondent 6 is allowed to file the counter affidavit, to which the petitioner, if so advised, may file the rejoinder affidavit to the same. This is matter after 2 weeks.
I do Lordship.
Item number 4.
I think Mr. Shulai is on legs in the other courtroom.
He's on his legs.
What do we do?
Otherwise, this is a small matter. My lord, it's only against the closure of the FR, where I was not heard.
Yeah, we just have to examine the, the legality of it and
Yes.
what are the, the law involved.
No, the law involved is that, Your Lordship, even in the closure of FR, the magistrate has to apply her mind. Now, you cannot say that just because the complainant had not appeared on a particular day, that is not a ground to accept the FR.
No, you have filed a show cause.
No, my lord, what happened here is that we received notice. It was during the COVID time, and my counsel had prayed for time to file a show cause against the FR. But unfortunately, the application was not put up before the court. That application by the PI, or whatever happened at that point of time. And so on the next date, the court closed accepted the FR. And we subsequently filed an application to recall that order. Now, rightly, the magistrate has held that I cannot review my own order. That is true. So the simple thing is that I just want to be heard. I want to file my protest petition before the magistrate. That is the only.
Lordship, I have
See, how do
no
we
instructions.
see one thing? How do we prove that you have filed your show cause and it was not put up?
No, not show cause, my lord. Adjournment. Adjournment.
Adjournment.
Yeah, it has been mentioned in the order itself also.
The impure order.
In the imperial order, my lord, I'll just.
Lordship,
No, Ms. Sham, you are there. You are competent. If it is,
I don't even have the file, my lord. I was just mentioned, Sir Shulai mentioned it just a few minutes back.
My lord, we'll just come to page 59.
yes.
Records put up today, instant application filed by complainant praying to allow the complainant to show cause on the final report submitted by the investigating officer. The complainant contended he had received notice issued by this court to file show cause to the final report filed by the IO, but the complainant, owing to severe health issues while recovering from COVID-19, could not file his show cause, for which he had filed a petition through his counsel on the set date fixed, that is on 17/11/2021. However, this court by order dated 25/11/2021 had disposed the instant case, citing reason that the complainant was not interested in pursuing the instant case. And my lord will come to the next page at 60, para 8. The complainant submitted that he had filed his show cause on so-and-so, but the same was not put up before this court. Complainant contended that since the matter is heard ex parte, hence this court can review its own order and allow the complainant to file his show cause. Now, the court, the only issue which the trial court had examined was that can I review my own order? Correctly also relying on the decision of the Supreme Court, the magistrate said, I cannot review the own order. But here, my lord, we have challenged not only this order, but more importantly, the order of at page 41, madam. My lord, will see a record put up today. EOC 1386 Frank C. Marwin, present and his statement recorded on oath and the same place on record. On perusal of their statement, it is found that notice was served on the informant personally, but the informant failed to appear and filed his show cause to the FR filed by the IO. Court is of the opinion that the informant is not interested to pursue the matter in spite of receiving the notice. The instant matter is hereby closed and stand disposed of. By this order, On the mere non-appearance of the complainant, the court had closed the, accepted the FR. The earlier order, my lord, is at 40, page 40. Record put up today, notice the complainant return after duly served, but the complainant found absent. On perusal of the case record, seen that the notice had been served to the complainant on several occasions. So and so to appear before this court on the date fix 25/11/21 for appearance. Supply copy of this order to the concerned. Now this order also was not supplied to me.
So, in such a situation, what would be the enabling provision for this court to, to give relief to you?
The relief, my lord, what I'm seeking is for setting aside this order of 25/11/21.
Exactly. But under what provision?
The provision is that non-application of mine by the magistrate.
That is true.
Yes.
You're citing a principle, not the specific provision. Is there any provision for the under the court which says that in the event the court is unable to to function in view of section 362, and what would be the corresponding powers of the superior court to undo such a situation or such an order? It should be present in a court.
Yeah, the only reason why this order was passed was not my presence was not I was not present on that.
We're not talking about facts, Mr. Taylor. Facts as it is there. Now we are looking to the legal aspect of the matter.
Legal. Now 174, my lord, 174. The magistrate is bound to apply her mind. Magistrate cannot say that merely because the complainant is absent.
Yes, you see, let's put it this way: the magistrate is wrong in all respect.
Yes.
So now you are to convince this court as to what are the specific provision which an order can be passed in your favor. That is what I'm asking.
No, I'm not saying any order should be passed in my favor. All I'm seeking from this court, my lord, is that
Mr. Taylor, you have come before this court.
Yes.
Lastly, with a prayer. And your prayer has to be answered either in the negative or the positive.
Yes.
If you want a positive result or reply, so you tell this court these are the provisions under which the court can take recourse to and pass necessary order. What is that?
I understand.
Either 226, 227, or
under the revisional powers.
Under 397 or whatever.
Yes.
Is this a revision?
Yes, this is a revision.
Oh, it's a revision.
Yes.
Lordship, I have to interject. Okay. This Lordship,
this is a revision one.
Okay. 397.
397.
I thought this is 482.
Yes.
Lordship, the learned senior has not instructed me at all, and he's asked me to pray for 1 week's time.
Can we let it come up next week? I don't know.
Prayer is made on behalf of the respondent on the ground that the learned AAG who is conducting the matter is indisposed. The same not being objected to by the petitioner. That is adjourned. Let's see after 1 week. Wait.
18th, my lord.
Yes, we can have it on 18th. This is around 18th. Michelle, 18th.
Item number 5.
Yes, Mr.
Illusive, in this case, already I filed my affidavit, and subsequently petitioner are saying that they will be giving some statement for the due statement. I have given my due statement for the entitlement.
Oh, that okay. That calculation.
Yes, Your Lordship. So in my petition, Your Lordship, I have admitted before the even filing the writ petition, petitioners be informed to give the details to make payment whatsoever the differences thereof, because these differences occur due to this court order, for implement the court order. So subsequently, according to our calculation, there was less, and we make payment. So due to statement also we
Yes,
given.
yes, that is true. The only thing is that whether the petitioner would accept that your calculation is correct or his calculation is correct.
So
Just have to-
accordingly, we make payment to him also by
Payment has been made.
yes.
Okay, he's seeking only the alleged areas
He is saying
or
alleged
differences,
areas the
or
citizen
the
part.
difference.
So I tell this, if it is, then he can even submit his calculation whatsoever he is having.
Yes, sought. None appears for the petitioner.